All rise.
Thank you. Y'all may be seated. All right. All right, Mr. Swilly, I did see, or excuse me, Mr. Swilly, said you stood another attorney, last name Swilly. I did see the suggestions you had made on the jury charges. I actually was going to include that in. I just didn't put that as in, but I was definitely going to charge that. Mr. Moody, by way of a charge conference, what I am charging the jury in this case is what their duties are as a jury to be the finder of facts. I'll explain to them again that I'll charge them on the law and that the law that I charge is the only law they can consider. I'll also charge them on the preponderance of the evidence. Mr. Moody, you have not put up a defense in this case, and you were in default by a prior judge. So I will also instruct the jury that as to the intentional infliction of emotional distress, that as a matter of law, you have inflicted or intentionally inflicted emotional stress upon the plaintiff. So I'll instruct them on that. And so what they will use their deliberation time is to determine what, if any, damages are a result of that intentional infliction of emotional distress. I will also charge the jury on the credibility of witnesses. I'll charge them on the elements to be considered on intentional infliction of emotional distress, so that they will know those elements when they're determining what the damages are. I will also charge them on proximate cause as well as actual damages, and then I will explain things that they can consider with actual damages, those things being pain and suffering, loss of enjoyment of life, mental suffering, and then I will also charge the life expectancy table. Mr. Willie, I'm assuming you're requesting that I charge life expectancy table.
Correct, John.
And how old is your client?
Okay. Right now, 52.
52. I'll pull the statute and determine what that life expectancy is, but we will charge them on that. Is there any objections to my charge, Mr. Moody?
No, sir.
Okay. All right. What we will do then is the plaintiff will have the opportunity to close. Mr. Moody, if you have any remarks that you would like to make in the form of a closing, I'll give you that opportunity as well. And then I'll charge them the law. Okay. Anything else before we bring the jury in?
No, Your Honor.
Thank you, ladies and gentlemen. As I stated yesterday afternoon before I released you, we've come to the point of the trial where we'll hear closing arguments, and then I'll charge you the law, and then after that we'll begin to deliberate on this case. I will tell you, as I told you before, what the attorneys say or what the or what the defendant may say in closing, that's not facts. Facts are based on testimony and what's in evidence. These are simply opinions, and it's what they want to show or what they believe the facts show. So I just want to remind you of that. I do want to thank you for your time during this trial. I thank you for the attention that you paid to the details and to the witnesses that have testified. I know that both the plaintiff and the defendant appreciate that as well. I will go ahead and allow the plaintiff to begin their closing argument, and they may be followed by the defense if he wishes to give the closing argument. Yes, sir.
Thank you, Your Honor. Well, I told you yesterday that we were going to try to get out of here in one day. That didn't quite happen, so I apologize for that first. But I'm going to be brief. I'm going to show you a little clip that I would like you to see, and then I'm going to explain to you what we believe the evidence has shown in this case about the damage that Dawn has suffered as a result of the intentional infliction of emotional distress that Mr. Moody inflicted upon her.
Well, Wednesday I got into my car and I turned my radio on, and this song came on, Rescued by Lauren Daigle.
To live within a moment, you were forgotten.
It's a beautiful song, and I knew they were searching for Brittanee, and I told them, listen to this song while you're searching for her.
Send out an army to find you in the middle of the darkest night. I will rescue you.
She called me and said it gave her hope. We were getting close because of the context of that song. I played it and listened to it while we were there.
For 13 years, from 2009 until 2022, while he went on living his life in this community, and all of us went on living our lives, Dawn sent out armies looking for her daughter. She contacted every law enforcement agency that would listen. She moved from Rochester, New York to Myrtle Beach, uprooted her life in order so that she could be there and be present and just be front of mind and keep Brittanee front of mind for the people that were investigating this. She put up billboards throughout the community with her money and with her effort, and worked with every group that would listen to try to find Brittanee for 13 years while he sat at home and watched the news, the same news that we watched if you were in this community then. It was a recurring theme. Everyone knew we were all looking for Brittanee Drexel. They asked us, look in every restaurant, look everywhere you go. She looks just like this. Dawn shared every photo she had. And he watched that and he said nothing. And you couldn't not know that this woman was suffering. We saw it. Because Dawn told you herself, she got on every media appearance that would have her because she wanted to keep Brittanee's face out there. And it worked. If it weren't for Dawn, you heard it from FBI agent Conley, we would have never found Brittanee. It was Dawn's efforts, Dawn's persistence that got us there. And it was everything she did over the course of those 13 years, uprooting her life to Myrtle Beach and then traveling appearing on national news with her grief broadcast for the nation, just to keep her daughter front of mind for all of us, just in case, that glimmer of hope that maybe Brittanee was out there. Perhaps she had been kidnapped and someone was holding her and she couldn't escape, and maybe somebody would see something or say something. Just that little bit of hope. And she lived with that for 13 years through the roller coaster of the ride that you saw on that demonstrative that I showed you in opening, which Mr. Conley indicated was accurate, but for the one point that we fixed. Solved, unsolved, over and over again while he watched, living right here, seeing the billboards, watching the news, and said nothing. There were marches, there were vigils. Over the course of those 13 years until Brittanee was found, Dawn poured everything she had into finding her. And for the last 3 years, Dawn has poured everything she has into getting full and complete justice in every way possible that our law allows. It's not going to bring Brittanee back. She knows that. She told you it's the principle. It's the principle, because if she fights this fight and she holds the people responsible in every way possible for what they've done, perhaps, some predator somewhere will have a second thought, and it'll spare another little girl. That's what we're doing. That's what we've been doing over the course of the last 3 years, working with the FBI, continuing to build cases against the accomplice, as you heard, who is now in prison, serving an 18-year sentence. That's what Dawn has continued to do. And she's continued to do that, by the way, helping other people. It's not just been about her and about Brittanee's case, but you heard from Kim with the Missing Link Foundation about Dawn being involved in other missing persons cases, because if anybody has experience as a parent about which levers to pull and which buttons to press and who to go to for answers and how to get things done, it's her. No one has done it like she's done it. And she's using those skills to help other people. But it won't bring Brittanee back. And we know that. And so the question that I, over the course of the last few years since Dawn brought this case and wanted to bring this case, that I've been wrestling with, is, what do we get out of this? Mr. Moody inherited some property along the way, so if your verdict allows money for her damages, then she will get that property. But as I indicated in my opening, that property isn't any measure of the damages that she has actually suffered. Dawn has always said that this is about the principle of the matter. And you heard her say that to you. It's what she said to Mike Conley when she went into his office and said, "Can you please pick this case up and look into this?" And as she acknowledged, without that meeting and without him accepting this case, it never would have happened. But he did because she did. And I'm doing because she did. And so I've thought, I've prayed, I have racked my mind about what do you say to a jury to value what this has done to her life. And I'm going to be honest with you. I don't really know. But here's what I do know. What I do know is that there's a lot of things that have happened actually over the course of just the last couple of weeks that have given me a way to think about it. I was watching the news and I was seeing about the billionaire predator ring, which we've all listened to, and about the clients and the private islands and all of that. And I thought, well, that's interesting. That's a good lesson that predators are not just at the lower rungs of society. They're all the way at the top sometimes too. Billionaires, high status, top people. Does the fact that he doesn't have a lot mean her damages should be diminished? Heck no. And then, just out of the blue, I was thinking about, what do we say about this? What do we say about a woman who's 52 years old, as the judge will tell you, has to live the rest of her life with this? And I thought about a painting. I don't know why, just did. The Mona Lisa painting in France. And my mind went to, well, how much is that painting worth? So looked it up. Don't know how much the Mona Lisa painting's worth? It's worth almost $1 billion. And as I was reading about the Mona Lisa painting, I read that if there were one scratch on that painting, if there were one pinprint, it would be worthless. I thought, that's interesting. And then, as I was praying, and I have been praying about this, I'm a praying person, maybe you are, maybe you're not, but that's how I process things. Some people meditate, some people pray, some people do whatever you do. It just kept coming back to me that it has to be a message that everybody at every level of society will hear and understand, that in this community we don't accept it. And I got out of Matt drove us here yesterday, and I got out of the car. God is my witness, and Miss Cindy's not a witness, but I gave it to her. I looked down, and there was a crucifix in the parking lot. And diamonds, silver, came off someone's necklace. And I picked it up. I brought it in. Actually handed it to the bailiff. She said, well, finders keepers. I said, no, ma'am. We had a little joke about it, but she took it and put it in the lost and found. And I still go, okay. Her damage is worth $1 billion. Because what he did to that picture that's on your screen of her Mona Lisa is far worse than a pinprick. She's had to live with it, and she'll have to live with it for the rest of her life. So when you go back there, it's a big number. I get it. The world's watching. Tell them. If somebody comes here and does this in our community, they're going to pay it all. Because it should. Thank you.
Mr. Moody, now is your opportunity to give a closing statement if you wish.
I'm at a loss for words. I just have so much regret, and I realize it doesn't matter how sincere I am about how I feel about things I've done. It's not enough. So, that's all I gotta say, Your Honor.
All right, ladies and gentlemen, you have heard closing remarks from the plaintiff as well as the defendant in this matter. And I will now charge you on the law, but before I do that, I want to go back and tell you a little bit about, again, what our duties are. And I remind you that during the trial, we have certain duties that we have to perform. And as the trial judge, it is my responsibility to preside over the case. And I have the duty also to rule on the admissibility of evidence offered during the trial. Now, you are to consider only evidence that's been presented before you. If there was any testimony that was stricken, well, you must disregard that testimony. You are to consider only the testimony which has been presented from the witness stand. Any exhibits, we don't have any in this matter, which have been made part of the record. I have the additional duty to you to charge you the law applicable to this case. And it's your duty as jurors to accept and apply the law as I now stated to you. If you think you have any idea of what the law is or what the law ought to be, and it does not agree with what I tell you the law is, you must forget that idea, because you are sworn to accept the law and apply the law exactly as I stated to you. Now, in every case tried in this court before a jury, the jury becomes the sole and exclusive judge of the facts. A trial judge can't comment on or make any statements about the facts of a case, since you're the sole judges of the facts. And I don't want you to think that any time during this trial, anything that I've said, any action that I've had, in any way has lent any thought or credence that you think that I may have an opinion on what the facts are of this case, because I don't. The law doesn't allow me to have opinions about the facts. What I'm going to charge you on first is the preponderance of the evidence. The burden of proof in this case is by a preponderance of the evidence. And a preponderance of the evidence simply means the greater weight of the evidence. It's the evidence which as a whole shows that the fact sought to be proved is more likely true than not true. This can be illustrated by imagining a set of scales. When the cases begin, the scales are even. Even after all the evidence has been presented, if the scales remain even, or even if they tip even slightly in favor of the defendant, then the plaintiff has failed to meet the burden of proof, and you would not be entitled to recover in this case. If, on the other hand, the scales tip even slightly in favor of the plaintiff will have met her burden of proof, and you should return a verdict for the plaintiff. The preponderance of the evidence is not determined by the number of witnesses. Instead, it must be determined by the greater weight of all of the evidence. I also charge you on the credibility of witnesses. You must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. It becomes your duty as jurors to evaluate the evidence and determine which evidence convinces you that it's true. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony. You may believe the testimony of a witness in its entirety or reject the testimony of a witness in its entirety. You must also think whether or not the witness is prejudiced towards either the plaintiff or the defendant, the opportunity for the witnesses to have seen the matters and things about which they testified, and the way the witnesses act on the witness stand. Now, in this case, there has been a claim made by the plaintiff for the intentional infliction of emotional distress. The court has found, as a matter of law, that the defendant did intentionally inflict emotional distress on the plaintiff. That is not an issue for you to decide. That has already been decided. But I will tell you the elements of the intentional infliction of emotional distress so that you can understand that when you're determining what the damages, if any, are a result of his actions. Intentional infliction of emotional distress or outrage means that the defendant intentionally or recklessly inflicted severe emotional distress and was sure or substantially sure that severe emotional distress would result from his conduct. It also requires that the defendant's conduct was so extreme and outrageous as to exceed all possible bounds of decency and must be regarded as atrocious and utterly intolerable in a civilized community. The law does not allow for damages for each and every occasion which causes someone mental distress. If that were the case, the courts would be flooded with lawsuits every time somebody's feelings were hurt. Instead, the plaintiff must show extreme and outrageous conduct. Extreme and outrageous conduct is not mere insults, indignities, threats, annoyances, petty oppressions, or other frivolities. Everyone must necessarily be expected and required to be hardened to a certain amount of rough language and acts that are definitely inconsiderate and unkind. Extreme and outrageous conduct, however, is conduct which would cause an average member of the community to react immediately in outrage. Intentional infliction of emotional distress also requires that the actions of the defendant proximately cause the plaintiff's emotional distress. Proximate cause is something that produces a natural chain of events, which in the end brings about the injury. It is the direct cause of the injury. To prove that the defendant's actions proximately caused the plaintiff's injuries, the plaintiff must prove causation in fact. This is proven by showing that the injury would not have occurred but for the defendant's actions. The plaintiff must also prove legal cause. Legal cause is proven by showing that the injury was foreseeable. This means that the injury occurred as a natural and probable consequence of the defendant's actions. The plaintiff must prove that some injury from the defendant's actions was foreseeable, but does not have to prove that the particular injury that occurred was foreseeable. However, the defendant cannot be held responsible for things which could not be expected to happen. Proximate cause does not mean the only cause. The defendant's acts can be proximate cause of the plaintiff's injury if it was at least one of the direct concurring causes of the injury. Finally, the plaintiff must prove that the emotional distress was severe, so that no reasonable person can be expected to endure it. Emotional distress means mental distress, mental suffering, or mental anguish. It also includes all highly unpleasant mental reactions such as fright, nervousness, grief, anxiety, worry, mortification, shock, humiliation, indignity, and physical pain. Although severe emotional distress is usually shown by shock, illness, or other bodily harm, these types of symptoms are not an absolute requirement for recovery of damages for intentional infliction of emotional distress. Severe means substantial or lasting, as opposed to trivial or brief. In determining the severity of the emotional distress, you should consider its intensity and its duration. As I told you, the court has found as a matter of law that the defendant intentionally inflicted emotional distress on the plaintiff. Therefore, the issue for you is if the plaintiff was injured and the actual damages to be awarded to the plaintiff. I next charge you as to actual damages. Actual damages are to compensate the plaintiff for the plaintiff's injuries or loss, and to put the plaintiff as near as possible to in the same position that the plaintiff was in before the incident occurred. In other words, actual damages will be the actual losses and expenses which the plaintiff has suffered because of the defendant's acts. Actual damages for a plaintiff who has been physically injured include pain and suffering, both past and future, as well as mental anguish, impairment of health or physical condition, and disfigurement. The plaintiff may also claim lost wages due to absence from work and reduced earning ability for the future. In determining the amount of compensation for these injuries, it is proper to consider past and present aspects of the injury. This would include physical and mental pain and suffering, expenses incurred for necessary medical treatment, loss of time and income, which resulted from the impairment of the ability to work and earn a livelihood, the loss of enjoyment of life suffered as a result of the injury, and any other losses which are reflected by the character of the injury. I next charge you as to what pain and suffering is. Pain and suffering compensates the plaintiff for physical discomfort and emotional response to the sensation of pain caused by the injury itself. There is no definite standard by which to compensate the plaintiff for pain and suffering. You have the authority to determine the amount, if any, to be allowed for pain and suffering, using calm and reasonable judgment to ensure that the damages are just and reasonable in light of the testimony and evidence presented in this case. I next charge you as to loss of enjoyment of life. Loss of enjoyment of life compensates the plaintiff for limitations on the plaintiff's ability to participate in and derive pleasure from the normal activities of daily life. The plaintiff must prove the expenses caused by the injury were also necessary and reasonable. I next charge you as to mental suffering. Mental suffering, apprehension, shock, fright, emotional upset, humiliation, and anxiety, either present or expected in the future, can be properly considered as an element of these damages. The amount of damages for mental suffering cannot be exactly measured. I charge you that in South Carolina, if you find that the plaintiff was permanently injured as a result of the defendant's actions, you must then decide how, if at all, that injury will affect the rest of the plaintiff's life. A person's life expectancy is determined by a life expectancy table, which is part of the laws of the state of South Carolina. The life expectancy table is only an estimate of the probable average remaining length of the life of all persons in our state at a given age. The plaintiff in this case is a 52-year-old female with a life expectancy, according to the life expectancy table, of 30.9 more years. This fact is to be considered by you, along with any other facts and circumstances and evidence bearing on the plaintiff's life expectancy, including occupation, habits, and health at the time of the injury, in deciding the amount of damages to be awarded to the plaintiff. Now, ladies and gentlemen, I have in my hand a verdict form, and I tell you that the verdict in this case must be a unanimous verdict, meaning that all 12 of you must unanimously vote on this verdict. To our foreperson, I will tell you that in the jury room, it is very, very important that everybody be given a moment to speak, that everybody be given an opportunity to express their opinions. I will ask you to be open-minded. I will ask you to listen to each other. There may be things that one person has heard that somebody else on the jury maybe didn't. That's why we have 12 jurors. I think it's very important that you take your time through this. And again, Madam Forelady, I ask that you give everybody an opportunity to speak. Now, as to this jury verdict, as I've stated, the court has found as a matter of law that the defendant intentionally inflicted emotional distress on the plaintiff. Therefore, the only issue for you is the amount of the actual damages, if any, to be awarded to the plaintiff. There will be 2 questions which you must answer. Again, these answers must be unanimous. And you are instructed to answer the following questions. And again, as I said, you must all agree on these answers. The first question is, we, the jury, unanimously find and answer that. The question is, do you find by a preponderance of the evidence that the plaintiff, Dawn Clacken, suffered injuries as a result of the conduct of the defendant, Raymond Moody? Yes or no? If it's no, the foreperson will sign the jury verdict form, will knock on the door, and you will allow the bailiff to come and get you. They'll come and let me know, and that will be the end of your deliberations. But if you answer yes, that she has suffered injuries as a result of the conduct of the defendant, then at that point, you will answer the second question, which says, what, if any, is the amount of actual damages sustained by the plaintiff as a result of the defendant's conduct? You will have an opportunity at that point to determine an amount for actual damages. I ask that you go back now into your jury room. Do not begin deliberating yet. I have a few matters I need to take up with the parties to this. I will send back the verdict form, and when I send the verdict form back, you will have an opportunity at that time to begin deliberations. Thank you. All right, anything from the plaintiff?
No, Your Honor.
Anything from the defense? No, sir. All right, I'm going to go ahead and send back the verdict form. I'm going to instruct the bailiff to go ahead and put our alternates in another room so they can begin deliberating. I don't believe there was any evidence that was introduced as far as exhibits, so they'll be able to begin deliberating at that time. Thank you. The alternates, if they can just